Yes.
Will be
No, fine. Yes.
Generally dispute involves a piece of land which was in the Sabuk record of file was recorded as Harinala for drainage of rainwater, excess rainwater and the wastewater for
On the drainage system, a building has come up.
Yes. Here
Is it encroachment?
is encroachment. Encroachment, it was in Sabik, it was reserved for public purpose in the drain. But subsequently, in the record of file, the opposite party managed to record his name and the land was recorded on Bharavali status. Therefore, but filling of the drain.
Is there no other alternative drainage system put in place today?
Drainage system is drainage.
Is there no drainage system put in place today?
Yes, drainage system
There is.
there.
There
Drainage
is.
system drainage system is developed, but Miller, the opposite part of line Miller, in Balai March with the settlement of it, managed to record the land in her name and filling the drain, she has started construction of a multi-story building. Therefore, we approach the authority, the collector.
How the PIL lies?
But
PIL is intended for raising or espousing the grievance of a poor or a person who has no means or who are otherwise impeded from approaching the court, then somebody can espouse the cause. You are a resourceful person having a shop, you are a shopkeeper, have all the means. How can a PIL lies?
Well, shopkeepers because
Simply because you wanted to raise that some construction over the government land, that means it becomes a PIL.
no, that is not that is the.
I am asking you, I have seen your petition, you have said that
Yes.
many inhabitants of the locality and the shopkeepers.
Yes.
The shopkeepers have all the means to approach the court. It is not that they cannot approach the court because of the economic stringencies or something of that kind. They can't.
But
How PIL lies?
But they are running small shops.
I am asking, there are nuances of the PIL. Tell me how the PIL lies.
Because of filling by virtue of filling.
That means a PIL. That's your personal infringement of your fundamental right. Then you can espouse your cause before the court. PIL means you are really representing the community as a whole.
Yes, ma'am.
Can you? When?
Like, the land is situated in the.
That means PIL. Tell me, I have read the wrong impression about PIL, maybe wrong. Tell me whether it lies PIL. Like
Ground
this.
number 5 itself shows.
Well,
You are espousing your own cause because you are suffering from their act.
but the petitioners suffering along with the petitioners, the others of the locality.
Others, are they so weak to approach the court? PIL is meant for that the others who cannot approach the court because they do not have the means, they are poor, economically absolutely weak, they cannot come. Somebody will come and espouse their cause. When all our shopkeepers, everybody has the means and resources, how the PIL can be done by you?
It's not all have been suffering.
So you have not made out a case. You have simply made out a case that the people of the locality and the shopkeepers are facing a lot of difficulties.
For the locality, that includes all the shopkeepers.
It seems you are all brothers.
Sorry, sir.
Business.
Satisfy me on PIL.
But some of them are source, but they are representing the local.
Sir, are you aware what is the scope of PIL? Just tell me. When I ask you this question, I mean you should be aware that what is a PIL.
Person has already explained the scope of the PIL.
So does it lie? I'm asking. Every time, why the division bench? A person will be losing a forum. Even a government may lose a forum. Litigant may lose a forum. Why? because any order is only amenable to be challenged higher up. But if we move to a single bench, then at least you can have an avenue of one appeal before the division bench.
We have already approved the authorities. Because of their inaction, we are constrained to approve.
Does PIL lie in this? What are the fundamental rights which is infringed? What are the principles you'll have to agitate and state in a petition?
But, in the rainy season, because of waterlogging, the people are facing problems.
But I have seen here the PIL is being misused to the greatest of extent. Since the villager has come, PIL. His representation not considered PIL. I have not. Show us. My mind is open. Show us. I don't think so.
Article 9 seems to be sister of petitioners. Petitioners are brothers. All the petitioners.
Not brothers, Miller.
They are brothers.
Somehow related.
Very perusal of the description of these names, that itself indicates they are brothers.
So they are not brothers. Large
Definitely, sir, you may not be knowing. Definitely they are brothers. And 9 is their sister.
9 is not their sister.
I'm sure.
Yes, ma'am.
They have come from Barampur and settled there.
They are coming from the particular category. That community is staying there. A large community,
Kind of a PIL is
community is staying there. Of these communities,
Sometimes I find that this court takes a very liberal view and do not go into that rigid aspect. But sometimes, sir, after all, a message has to go somewhere.
you will also kindly see here the notes.
If you are sanguine, you argue, then we'll decide that is there. No, argue. There is no difficulty. We can't prevent you. You can argue.
My only prayer is
That is why I asked you, Mr.
That means a PIL. We will say that mere inaction on the part of the authority raises a PIL, public interest litigation.
Because it is for public purpose, therefore,
Yes, sir.
we have approached.
Is it not a public publicity interest litigation?
No, absolutely.
Or a personal interest litigation?
Not also personal interest. Because of the suffering of
Para
the people in the
4,
rainy
see,
season.
sir, para 4 of your representation, that itself.
What do you say, Ms. Patnaik?
Lordship, the photographs here is suggesting for photographs claiming that the entire region, left and right, everything is a
No,
construction.
Pani Nala.
But,
ROR shows it is Pani Nala.
but they,
How can they encourage open Pani Nala?
he's saying that it has been settled.
That's why I drew his attention to para 4 of the representation. It is settled in his name.
I do not know. This is in the
ତାଙ୍କ ଦାଦା ହେଇଥିବେ ସେ।
script. I can't
ଯାହା
read.
ନାଁରେ ସେଟଲ ହେଇଛି ତାଙ୍କ ଦାଦା ହେଇଥିବେ ନାଁରୁ ଜଣା ପଡୁଛି ସାର୍ ତାଙ୍କ ଇନିସିଆଲ ସମସ୍ତଙ୍କର ସମାନ ସାର୍ ତାଙ୍କର ଇନିସିଆଲ ସମସ୍ତଙ୍କ ସମାନ ମୋର ଏମ୍ ହଉଛି ଇନିସିଆଲ ରମନ ଟା ମୋର ଟାଇଟଲ ନୁହଁ ସେ ଇନିସିଆଲ ରୁ ସବୁ ଜଣା ପଡିଯାଏ ଆଉ ସେମାନେ ବ୍ରହ୍ମପୁର ଆସିକି ସେଠି ସେଟଲ ହେଇଛନ୍ତି
All are from Baram.
ହଁ ଫୁଲବାଣୀରେ ଅଧା ଲୋକ ବ୍ରହ୍ମପୁର
All are from Barampur and in
ସେପଟେ
Fulbani,
ଭଞ୍ଜନଗର ଲୋକ ଆସି ସେଠି
80-90% persons are they are from Barampur.
Sir, I could not read that representation, but at least from the petition, I could gather that it is you are really trying to settle your personal score.
Not
Not PIL. No, sir. Nothing. Sir, if you have any grievance, you can go and raise a grievance. PIL, every time PIL. And when the land is already settled in your favor, this is also very interesting.
It was originally government.
Do one thing, if it is illegally, Ms. Patnaik, if it is illegally settled, cancel the settlement. Cancel the settlement. His settlement will be cancelled. We are taking in a larger perspective, make a full extensive inquiry. If any land has been settled without following the procedures, if it was recorded in the public, say the government land or is a public utility, then in that event, whatever the settlement has to go. And he should be removed from that He will be removed from his place immediately. Yes, we are passing a directions. He will make, and he will be removed if it is.
That is settled in favor of the opposite patrol 9 million.
No, sir. Maybe your cousin, your brother, whatever. Everybody has to go.
Yes.
Yes, yes. Even you. No, no.
What is this WPC 8561 of 2010?
That was for early disposal of the revision petition.
That was before the single bench.
Yes.
This time, why you have approached the division bench? You can't choose a forum.
That was for early disposal of the revision.
Is it not? Is it not? There is already a proceeding which was initiated and it has been settled in the name of a private individual.
So I said that.
Uh,
So there was a revision case. The revision case was not getting disposed of. So
So he approached the
writ court.
and the revisional case is disposed of and settled and did not find the settlement to be wrong. Is another device. He approached the writ court.
Who has approached the writ court?
Not the present petitions.
Who?
The opposite. He has approved the.
9 approved.
For early
So
disposal.
revision case was filed at her behest.
Yes.
So
Was whether you were a party?
No.
You were not a party. So if there is any order of the revisional court which affects your right, then you can approach the court challenging that order of the revisional authority.
Yes,
You can't take this PIL route and then get this order set aside. How?
are you in possession of the same patch of land?
No. Because it's
She has a different patch of land.
Appeal of the debt.
She has different patch of land.
Yes.
So that is settled in her favor.
So,
So
and now you are making an inquiry saying it is Nala. That means we have to reopen the entire issue without challenging the order of the revisional authority.
The present petitioners are parties to the.
Maybe a person who is affected by any order or any adjudication made, can he not go to the forum challenging that order that this order is per se illegal?
And the order passed in the revision also was not within their knowledge recently when they filled up the drain.
So I do not know that you yourself has said that it has been converted as a stitiban.
Yes,
So once it is a stitiban, it is then is a wrong recording. Then you will have to challenge that order. Why PI?
But once it was a government land and it was for public.
Sir, that means suppose let us have the interaction. Suppose what you are praying we are passing a direction. What will be the effect of this direction? That the order of the revisional authority has to go wrong conversion of the land from Nala to a Stitiban without challenging. There is a provision under the act which says that you can challenge that order before the authority. This is impliedly you wanted another circuitous route to get that order nullified. Can you do it through PIL? I'm asking this question.
With that observation, you will also dispose of the.
We are discussing that this observation with these observations.
But in the revision petition, petitioners are not parties. And
Sir,
it is also.
sir, are you not aware? You are a legal expert. Are you not aware that even a person who is not party to the proceeding, if any order is passed affecting his right, he has a remedy under the law to challenge that order? Can you not challenge that order
His personal right is not affected, it's a communal right. His personal right is not only affected. It is
Communal right or a community
It
right?
is for the.
What is this? What is the appropriate word? Communal right or a community right?
Community.
Oh.
The right of the community.
Okay. So,
Land was a communal land.
so will you not approach? Is there any other forum? Can you not challenge it in the writ if there is no further appeal against the order of the regional authority? You're not challenging that order.
No, I'm not challenging that.
That is the irony of the thing. You wanted something to be done indirectly, not in a direct manner.
In a true sense, what happens, the mall is coming up on that plot. So their business, they are also business people. So their business is
They
affected.
do not want competition. Even after the competition law has come,
That
they
is
do
the
not
only-
want competition.
That's why that opposite party number 8, who belongs to Kolkata or West Bengal.
So, who is the opposite party number?
That mall owner.
Party number 9 in
City Bazaar.
You must have the business adjacent to that mall.
Understand, but
And-
it's a medicine
And
store is
in a similar line of
The
business
medicine
which you
store
carry
was a
on.
medicine store.
What?
And that is a garment store now that will be open.
The
Yes, but actual code, the authority invert this is a bridge work. The petitioner completed the bridge work except few items which land acquisition as required below.
Final
9
bill is
January
not-
2025.
Final bill is not prepared.
Final bill not paid. Closure below there is a.
You wanted an admitted dues to be.
Yes.
Yes, Miss Patnaik, why you are not paying?
Also, the closure proposal has to be finalized by the.
What?
There is a closure proposal recommended by the
When was it
authority.
closed? When the work was over?
Initial code is 2024.
9/1/2020.
26/9/2020.
So why you are not paying?
Except few.
We direct the tribunal take a decision on the closure proposal and pay the.
Why?
All the instructions are also-
What is this closer proposal and then to take?
According.
Wow,
to
you
this
can't,
petition, there is a
how many time, how many days you require to go and inspect the entire construction work and give a closer proposal?
There is a stretch of land which belongs to private individuals.
So
So since that was not required, he had asked for a closure of the.
obviously, because he can, you have to provide a
That
land.
has been accepted by the the project office concern. It is pending for the chief engineer. That is.
So how, when it was proposed by the other authority, then a chief engineer? What is the date?
First 9 January 2025, thereafter 13 January 2025.
So-
Almost 8 months.
Now we are in the month of November. Nearly 10 months have expired.
Should I give me a week's time and put the instruction?
What
for the
week's time?
lodging to dispose of the way saying that the closure proposal.
Nothing. We'll have to complete and make the payments of a lawful admitted dues. This is, brother, will you write? Huh?
Obviously.
Yes. we will do.
Item number 3.
The challenges, demand of this, was transport is fee on more. Similar to concept parts or. Forward judgment of this. That is the requirement.
Local vendor. Local vendor.
Yes.
Yes.
Somewhere we have written that local outsider.
Yes,
Local outsider.
Local outsider, how can it be?
local parts.
Yes, next.
Item number 4.
In this case, the petitioner, the students are challenged, man.
Students are challenged
What I meant, I'll try to complete. So
or students are challenging.
Yes, ma'am.
Say you students are challenged. I got shocked.
And so affecting
Yes,
students, because of their financial crisis, they could not get admission because of the authorities director amendment by Annex 2.
Where, which school?
This is the MBBS admission and NEET PG admission.
So NEET now it is everything is over. I think the Supreme Court has given a last deadline.
That is the judgment.
It's a painting, annex
Bhavana Tiwari versus one of the.
They moved.
and the substantive filed by the aggrieved party at annexure 9 are entitled by Honorable Justice Master and Justice Dinesh Sahu, and those matters are pending as in the same notification.
Yes, ma'am.
And the
So
next,
why you have come before us?
Well, here is the number of students. There is small student of.
Sorry, the number of students and small students, how it makes a difference?
Well, here is the.
No.
The financially
Brother,
affected.
That was not.
same point.
Well, same point.
That was not PIL, this is
This is
PIL.
PIL.
So
next date is 27th.
like, in course of an hearing, we notice Affidavit does not talk about the sale. It's an individual affidavit. So how can we treat it?
Malad will file, and can pass on.
What file?
The affidavit can be modified.
No, how can you? How can you? Affidavit, amendment, unheard in the legal parlance, till date. I have not seen it can be done. How can you amend the affidavit? Sorry,
There will be disclaimer.
sorry, it can't be.
Then,
Then it has to be dismissed.
Malad, can you permit me to also to file a better for the student, for the benefit of the student?
Whatever,
Yes.
go before the other. Get it out, memo? Yes.
The particular will given, man.
Okay.
We'll file a better application.
Item number 5.
You don't talk about CORAM, as you
Item number 5 minutes regarding non-constitution of GST agreement.
Are you coming within the bracket of that period where you can file?
Starts from December. So for different period of assessment, different period of filing has been given in that.
That we know. That's why I asked you this question. Are you coming within the period or
No, still not.
still no? Yes. Next.
Item number 6.
Item number 6, Your Lordship, is a service tax matter. All three are service tax matter regarding 73(4)(b, Your Lordship.
So,
is-
Sinner, I dropped it. What is there? Yes.
Item number 7.
Yes, Lordship.
Proceeded under section 129 of the GST Act. While the ingredients are not available,
Huh?
while the ingredients are not available in the into notices.
What do you mean?
Ingredient of the section that needs to be fulfilled before proceeding.
Are you challenging the decision or are you challenging the notice? You are challenging the notice. Where is the notice?
That is under Annex 4 units.
For transports or the stores any goods while they are in transit in contravention to the provision of the Act, that is section 129(1). Show us the GST.
The finding of the official also can always.
Is there any statement which will corroborate this, or is the only this statement?
Except page 20.
That must be a narration of the facts. That's why.
Annexure page 20. That followed by annexure 2.
True.
Page 20 is the finding units.
Where?
Page 20.
Annexure 3.
Annexure 2 series is the finding of the officer. The relevant parties are page 21. Basing upon which the notice has been issued to them. Page 21. That is form GST MOP 06.
That was an inspection.
Yes, sir. The recording of the reason.
That's true. Then what about the annexure 3? Is the outcome of that?
Yes, sir. So,
The vehicle was intercepted. Cellulose wedding and waves of the cellulose fiber.
Yes, sir. May I take your license to page 21 first and 6?
I have seen that.
That is the recording of the reason that is that prior first said the documents rendered are found to be defective. First point. Next, the
Anyhow, then tell me, then they have given. Then what about 129? What are the ingredients? Show us.
Before going to law university, I may place the fact university there. The what is recorded on the page, at page 21, it is the wrong statement of the officers.
Yes.
At page 21, it has been recorded that the documents rendered are found to be defective. And what are the documents? The genuineness of the goods in transit, its quantity, etc. under or
Madam, there are three grounds they have
Yes.
said.
For-
One is the ground tenders are found to be defective.
defective. Next is
The genuineness of the goods in transit and the tender document. Further verification, e-way bill
Not tendered.
not tendered for the goods in movement.
Yes.
It must be relatable to something else. Correct. So now they wanted that a physical verification.
Yes.
An order for physical verification is required to be done, served on the owner, and inspection would be done on this in movement.
21% kindly have a glance at page 19 units. Page 19 is the e-way bill. The authority has said that there is no e-way bill, and page 19 is the e-way bill and the tax invoice that is under Annexure 1 City Jewelry. It is very much there. That is at page.
So there you go and show them, give a reply. Go. It's a simple notice inviting you that why the proceeding should not be initiated. You just go there, give a reply, give them all the documents. If they are satisfied, definitely they will not proceed. If they are not satisfied, then
Under Annexure 129(3), I have already deposited the penalty amount because
so only for the purpose of release.
Yes.
Madam,
That's all.
after the reply, they will pass an order. Against that also you have remedy.
Oh, that is what I'm saying.
So why should at this stage?
Only my.
And see, somewhere you have stated that you have not gone by the road, which was.
That is because of the GPS navigation. Because of the GPS navigation also.
So you should have while
But the finding is.
while applying for way bill, you should have been very cautious.
No.
Nowadays, that is stringent actions are taken on that.
E-way bill is very much correct and the address is very much correct.
Sir,
According
when they say that it is defective, they did not say ingenuine. They did not say spurious or a forced one. They say it is a defective one. Defect in the sense that there may be something missing, something which is required to be disclosed, not disclosed, whatever be the reason. According to you, you have disclosed everything. Way bill is perfectly correct.
Okay.
Go and give a reply. Give them, convince them. If they are satisfied, no problem.
Annexure 3 university, they have stated that the address is different, but address is very much there and the arrival.
Madam, go there, convince why we will prejudge. Can we usurp the power of the authority under the law and decide everything? You have to go there. You know the limited scope of the notice.
My limited not that, but I have deposited as the penalty
So
amount.
if the I think section 129 1A and B permits you to have the release of the goods upon payment. If you have made the payment, they will release the goods.
Already made payment and already proceeding has been concluded. He has made the payment.
No.
And your lordship has settled the issue.
So that-
Once the payment has been made without any protest, your
To
lordship.
that effect,
In
makes
two cases, your
there is-
lordship. Earlier, the bench, Honorable Chief Justice, the then Chief Justice, my Lord Justice Honorable Rama. And
may,
your lordship has cognized that judgment at paragraph 18 of your lordship judgment.
prior to that,
In
may,
last judgment, your lordship,
Lordship,
paragraph 18,
there
page
is no
35.
such provision under the act that we will pay
Page
under.
35, paragraph 18, your lordship judgment.
DRC 03 is the only mode through which the petitioner can pay,
No,
and that is the voluntary
that
payment.
could have been paid,
There is
the
no such,
security could have been paid.
There is-
If
there is no
if the
such-
petitioner wants to protest,
there is
then
no
that
such
can be
occasion
released
for
and
the
put-
petitioner to pay under protection also.
page
It is
35,
admitted
paragraph
that-
18, in your lordship judgment in Viral Steel. And the earlier judgment of.
Show us that this was paid under protest.
And
Where is the document
That is.
that you have written that it is
Yes.
under protest?
there is no such occasion also because DRC 03 is the only mode of payment.
Annexure 5.
Have you immediately written a letter while making the payment or before making the payment?
No, Your Lordship, because.
So I am bound by my own judgment. I can't resile therefrom. Tell us, show us paragraph 18. Read paragraph 18.
And
I think,
5 page 29.
this time my brother was not a part of this judgment.
In the earlier judgment, my lord was just
Whatever.
your lordship has quoted that judgment. My lord was a party.
In that judgment.
No, this.
And that's why I asked her whether she
Nothing.
would be wishing to go in alternative remedy or not. That's why I asked her.
And already proceeding has been concluded. I have taken instruction. Your lordship have submitted that MOB 5. That MOB 5.
Now nothing
The
can.
goods have been released.
Yes, yes.
The vehicle have been released, your lordship. And on his driver's statement, the vehicle has been gone to
Gone to?
Bhubaneswar or to another place. His driver's statement is there.
Can't.
Recording of the official.
Madam, there are two modes. When you are making a payment on the same day, simultaneously, you should write a letter to the authorities that I am making this payment, I am putting it under protest.
That part is not.
The
Yes. But the
once
recording.
you have not done, and this is my observation,
The
that at least the document does not show that the payments were made under protest. If it is not, then you have lost the right.
But you have said the recording of the authority that the place of the e-waybill is absent. That is wrong, Your Lordship. Prima facie on record, he is having the e-waybill.
I mean, in a very truncated manner, can I say, if your entry into a shop is restricted, can you say that this particular item which is kept in the shop room is not kept in a proper place? You have not been allowed to enter. How can you go and say, here, your right to approach the court is closed? It says once you make the payment without protest, you cannot resile therefrom or challenge and say that, no, this is wrong. When this right is foreclosed, can we enter into the merit whether it is a correct address, it is not a correct address, whether it is true, it is not true? How can we go into this? Sir, you should.
You want the order to be passed or you will so
I would wait. I would wait.
Yes, call the next.
Gratefully.
Item number 8.
I think the cancel.
9.
Item 9. Thanks. Item number 10.
Number 10, we are going to DCA. We have to. Challenging the governing related to even to signatures.
Just 1 minute. The why it is fresh admission, this is many times this matter has been taken up. Then what
and
is
the
coming?
condemnation was done, then it is for admission.
Oh, directed the matter to be listed.
For admission.
This one. Where is the inquiry?
You are appealing for.
You are challenging an order dated 22nd October.
Mine.
Yes, give us. Who are you?
And the petition.
Sir, everything is granted in your favor and you are coming up before and challenging the order before this
Only
court.
with regard to restoration of the seniority. Otherwise, yeah.
What are you talking about such a restoration? It is only you have expired, superannuated in the meantime. What more?
Retired in 2015.
Sorry, you are not entitled because you have been put into the last rank of the junior engineer.
Because your lordship, the punishment which has been imposed on me, my lord, your lordship can read the.
Sir, it is degraded to a post of a junior, whatever the clerk or an engineer.
My assumption it was
At the last.
Junior clerk.
It was for
At the last. Whatever.
Yeah.
That is also not challenged.
No, that I've seen.
Huh.
And now he wanted a seniority. How?
No.
No, only for the benefit of the some financial. Otherwise, nobody is affected by that.
Whatever you think you have been demoted, you did not challenge the order of the disciplinary authority, everything was not done.
After 5
And
years,
the
they have
London
restored-
judge has accepted your contention that when there is no reference, a specific reference, whether the stoppage of the increment is with or without the cumulative effect,
Yes.
he says that it is without cumulative effect.
No, it was not mentioned in the, whether it was.
That's why he says that when it is silent, it is always presumed that it is without cumulative effect.
Only my prayer with regard.
So that goes in your favor.
With regard.
If it is with, then you are all gone.
They have.
In fact, the order of the learned single judge has been given effect to, has been complied with by
I
the.
have to- They have already extended the financial year. My prayer was twofold.
No, it can't be. It can't be. You can't get a seniority in that way. And in the meantime, you have already attained superannuation.
Only with regard to some financial.
No,
pension.
it's not a bounty or a charity to be done by the employer. You must show your legal right. You must show your legal right. What is your legal right?
Sure, because for the 5 years, they have extended the financial benefits since they have been, state government also held that for 5 years.
How can you put to a senior clerk? How?
No, at present I am not claiming, no way I will be given the seniority, only with regard to the financial benefits.
What financial? As a senior clerk? When you have been demoted and you did not challenge the order of the disciplinary authority.
Your prayer in the writ petition itself shows to fix the seniority in the grade of senior clerk.
How
at
can you,
appropriate place
when you have been
that is
demoted,
kept before gradation list under Annex 2?
when you have been demoted, how can you? What is the purpose of demotion?
That was
Does it evaporate the moment then?
only since it was for a particular period, that was.
Sorry, you should challenge the order of disciplinary authority. You have not challenged.
Yes.
Then you can't do it. At the very outset, we must record that substance What has happened?
I am in person, sir, for the recruitment. CPSC.
What order you are challenging?
Sir, 3 year age relaxation government is given.
What is the order we are challenging? Order dated?
Order dated 24 July. WPC 399.
Where is the impugned order?
Sir, interim, it is already, sir.
Just 1 minute.
It starts from page 77.
There are many writ petitions which we are disposed of.
Yes, my batch of matters were disposed of.
He is in which matter?
Age relaxation, sir.
He's in
No.
resolution number 3956. 956 of 2025.
3956. He is along with others.
Yes, ma'am.
Sir, government already given 4 year age relaxation.
Just whatever. Has he made the others as a party?
No, my lord.
What is it's a writ petition or a writ appeal? So where is the document of the writ appeal? Writ appeal. How can you leave out the other persons who joined with you in a costing?
They have not violated the order.
So what? But they are to be made as a pro forma. That is a procedure of law.
Sir, if 4 year age relaxation is given, because they will.
Sir, the difficulty is you are appearing in person, though represented by a lawyer. There are procedural law which is applicable to the court, and the courts are guided by a procedural law. The procedure of the appeal says that you will have to make all persons as a party who were the party in the writ petition. Whether they challenge the order or they do not challenge the order is immaterial. But they have to be made a party here. So you have to make them a pro forma respondent here. Though they have not challenged, they joined with you at one point of time. Will you not make them a party to correct the record?
If 4 year age relaxation is given, they will.
Sir, that is your perception. Our perception of law is different. Because we are guided by the law. We are not guided by the sentiments.
Yes, sir.
So we have to follow the law. You are coming before the court of law.
The government already approved our resolution and given 3 year age relaxation.
Are you understanding what I wanted to say?
Yes,
You
sir.
have not understood it. Yet you are going government granted 4 year relaxation. First thing is your appeal should be in proper form. It is not in proper form. First, it is brought in a proper form. This is what I wanted to impress. Make them, just help them, just to make them a party as a pro forma.
I may submit one thing.
Pro forma, so that at least they cannot say anything that they have not been married as a party.
Submit only one thing, my lords. This order, impugned order has been, the impugned order was passed after considering concession taken by the petitioner's counsel also, my lords. And government as one-time measure had granted 3 years age relaxation. And the petitioner counsel, so by appearing in the writ petition, has accepted the government's benevolent decision.
Where is the concession of the
Page 90, my lords.
Sir, council.
Just 1 minute.
Before accepting.
Just 1 minute. 90.
Page 5.
Where is the concession made by him?
24, my lords. Learned counsel appearing for the petitioners.
Which petitioners?
All the petitioners are, my lords.
This cannot be, whether his counsel has admitted.
And then subsequently, my lords, this recruitment, because of some irregularities found in this recruitment process, my lords, has gone to CBI for investigation.
Not only this
And the
recruitment, sir.
recruitment process.
Which one?
This
Sir,
present
in
in
2000.
No, this relation to what?
relation to Sub-Inspector of Police recruitment.
Oh, we have already, that's our order, we have already sent for CBI inquiry. There has been a lot of prima facie materials which has come. Again, that's what is a star or something? What is the company?
Sir, one thing I think only, sir, sir, in 2018, they have made repeatedly corruption. 2018 and 2019.
No, we have already sent it to CBI. We found there are serious allegations,
Sir, in their
serious
side-
materials. No.
Sir, in that time, 2018 and 19, during the previous moment, sir, we have faced the such type of consequences in our life that our career is ended, sir. Because, so if
But we will not allow, if there is any kind of corruption that has come, no, we are the last person to.
Please, Your Lordship.
You serve the copy.
Your Lord,
Caveat,
I am finding in my that their caveat is not entertainable.
caveat is not. Why the caveat is not entertainable?
They have filed the caveat
Hmm.
on the ground that they are members. The matter relates to no confidence motion against the sarpanch, sitting sarpanch. They have filed this caveat on the ground that they are members of the Gram
Sir,
Panchayat.
whether they were a party in the writ,
In the judgment, their names.
are they a party in the writ? I am asking you, sir. First, please tell me yes or no.
Their names do not appear.
They were not a party in the writ. Let us see the writ petition.
My Lord.
Page 9. Page 9. Yes, show us
Judgment.
who has lost the caveat.
petition number 3 or 20.
Oh, this is the IA. Where is the caveat?
Caveat is not found.
When the writ
Sir,
petition,
let us see caveat. Do you have a copy of the caveat? Give it.
Mr. Counsel, in the writ petition, you are not party.
Yes, ma'am.
You are party.
Yes, ma'am.
In the writ petition,
This is the order that implicated as the party.
The caveat is filed by the Santosh Kumar Bhoi, Anil Kumar Patro, Patrasan Behra, whether they have been made a party in the writ.
Yes, ma'am, that order is passed.
Yes, show us.
in the writ, I don't find.
They have not changed the cost title. Hmm. So they were impleaded as opposite party number 5 to 13. If a person who is arraigned as a party in a proceeding, if he has lost a caveat for an appeal, then that caveat cannot be rejected. 148A does not invite any cancellation of the caveat.
I am submitting.
It has a limited duration.
Your Lordship, I-
From where this conception of this IA comes, I do not know.
No, because they had filed this on the ground that they are members of the Gram Panchayat. They do not.
Whatever be the reason, sir, if a person has lost a caveat, he was arraigned as a party, he is entitled the
Your
notice.
Lordship has directed and I am serving a copy.
You have not impleaded them as a party, your even appeal is defective, sir. Your appeal is defective.
Because their names do not appear in the
What are you talking about? This is an order.
judgment, Your Lordship, I kindly.
Please, judgment does not reflect the full cost title. Judgment simply reflects the others. Does it contain the full cost title? Then,
Page 9 of the judgment.
sir, this is what you supplied
That has been.
for the certified copy.
That is a certified copy.
For giving a certified copy, you have applied. You have not amended the cost title of the writ petition. You never gave the amended cost title. Show us the writ petition. Yes, show us the writ petition. Writ petition, not writ appeal. Huh? No.
Hard copy is not. It is there.
Where is the hard copy?
Asini.
Asini? You can't do.
I am serving a copy.
Serving will not do. You'll have to implement them a party as well. Huh? He has not served the amended copy. Huh?
Order dated 23/7/2025.
This is the order.
IAS disposed of with impletion of interveners as opposite party number
Yes.
5 to 13.
Yes, this is what.
Yes. No, that's why I got confused.
What's your good name?
Isman, Sitaman.
Record his name. Call the name.
I filed an application for interim stay. I have filed an application for interim stay. When in the
If the caveat is lost,
respect my submission.
my
No,
section 148 capital A of the Code of Civil Procedure says that the court will not issue any interim order unless the caveator is noticed. They have a right to make the submissions.
I'll be doing it by tomorrow. Let it be possible day after.
First, you implead them as a party.
By tomorrow.
Do it. We have said here and now. Implead them here and now.
My lord, yes.
Serve him a copy
My lord, sir, I'm serving a copy.
of the writ appeal.
My lord, serve a copy. I'm doing it now.
Please do it.
Best of.
Next week.
Tomorrow or day after tomorrow.
No.
On 10th? I'm sorry, on the 17th?
Next week it will be there, 17.
May I please? Your Lordship, last order directed the government state commission to take instruction about the matter.
Why the money is not given?
In fact, when argument was advanced on the last occasion, that the petitioner's shop had been sealed for the month of April 2024. That is why, it was inoperative. Now, my instruction says that the shop was not sealed at all. In fact, the license period expired on 31st of March. Thereafter, for 1 month, the petitioner applied for renewal of the license on 10th April. And within 17 days on 28th, it was granted and became operative after that. He applied in the month of April. He applied belatedly. Now it says that that month.
Then your Lordship kindly see Annex 3.
Page,
Annex 3.
page,
Page my lord, 15, next 15, need copy.
page.
16. Page 15, your Lordship kindly see. Page
Yes.
15 is the next page, paragraph 2. It is the inquiry report of the letter Inspector of Excise Anand. Paragraph 2. I checked the challan of the shop. Consideration money for 4 months, April, May, June, July, in advance has been deposited. License issued dated 29/1/24. It started functioning after getting the license. Prior to that, after the sale hour dated 31/3, the shop was under close, under seal. The shop has 3 branches of, but those are not functioning due to non-availability of suitable and objectionable sites. Unutilization pass was issued on dated 6/5/24 and 16/5/24 for so and so quintal and so and so quintal. There was no loss of excise revenue as alleged. So also there was no supply of waste liquor to the local and nearby area by the EPH. In view of the above, it is ascertained that there is no violation of license by the EPH. The allegation petition of Sri Pushanandra.
So where is the original copy? It's a typed copy.
Yeah, and the first copy is the original.
First,
Page 15.
no, is not. That does not contain a signature at the bottom.
Yes, sir.
You have given it to me.
Just-
That is the next one is another letter.
No, my lord, before the page. Before the page. My lord, that.
This 14. This is the 14th.
You not 15.
Yes. 15, you are referring this letter. You read second paragraph. I checked. Sir, why you have not annexed the original?
I think, but this is the copy. It's there, my lord. I have checked.
Please check. Is there? Sure.
In the-
Where? No,
In
no.
the net, my lord. In
Sir,
the net.
you have to annex the copy, sir.
Something, my lord. I think-
Yes, he has.
In the net, yeah, it's.
Sir, it is pointed out defective because it is unreadable.
No, in my copy, it is not there.
It is.
I have sent him to find out. I
But it is uploaded. Uploaded. You must copy.
So I have to share. Look at. He is referring. He is referring page 15.
My lord,
and says that it was sealed.
my lord, what the
How can you
authority
say
says-
that it was
My lord,
not sealed?
My lord, may permit me to read. I checked the challans of the shop. Consideration money for 4 months, that is April, May, June, July 2024 in advance has been deposited.
Correct.
License issued on 29/4/2024.
Yes.
So 29th license was issued. It
Please.
started functioning after getting the license.
Correct.
Prior to that, after the sale hour dated 31/3/2024, the shop was closed under seal. It does not mean it was sealed. It was closed. I'll show my lord.
What is the meaning? I do not know, sir. I am very bad in English. When it says closed under seal, that means what does it mean? Why the seal will come?
My lords, may see page 7 first. My lords, I'll take my lords through 1 or 2 pages. Page 7, my lords. This is the license. The point number 1, the license shall remain valid. At page 7, my lords. Point number 1.
Yes.
The
31st March.
31st March. So, my lord, the license ended on 31st March. Now, my lords, once the license ends, my lord, the shop has to be closed. It cannot continue operating, my lords. Now, my lords, will kindly see page 13, my lord. Page 13 is the original document. The neat typed copy is on the next page, annexure 2. On the next page, there's a neat typed copy.
Yes.
My lord, the heading is Acknowledgement License Renewal Application.
Yes.
Now, my lords may see entry number H, which says application for the period. So, the period for this application is, my lords, 1/4/24 to 31/7/2024. It is to be granted. Now, my lords may see entry number L, application submitted on 10/4. So, my lord, the petitioner had not applied,
N.
my lord.
N.
10, my lord,
L.
L, my lord. Application submitted on 10/4.
Yes.
So, my lord, he had not applied for renewal prior to the last day that was, my lord, available to him for operating the shop.
Correct.
Now, my lord, the liquor policy of the relevant year, my lord.
What is the meaning of the word, the K? What is the word K?
K, my lord.
Yes. Application prepared.
prepared.
I do not know. Prepared and submitted by two.
My lord, that also I do not know, my lord. but-
How do you know when he has prepared the application?
My lord, my lord, may see the bottom of the page, payment details. Payment details. It says, my lord,
Receipt of 8/4.
8/4, my lord. The payment was made on 8/4, but the application was, as per, my lord, the records, it was submitted on 10/4.
Yes.
So what, be 8/4 or 10/4, my lord? That doesn't.
Signed on that.
So be it 8/4 or 10/4, my lord. So, my lord, my humble submission is the application had to be made
Why you use the word under seal?
under seal, my lord. That is, that's my lord's. It was closed. That should have ended there. Under seal, my lord, seal because not
That
seal,
means
my
that
lord.
immediately on 1st of April, you went and sealed the shop.
My lord, because he did not have a license to continue with operating the shop. That is why
That is
no.
Will you charge any amount from 1st of April when you renewed the license?
My lord, may see the liquor, the excise.
What is
policy.
the liquor, the renewal right license?
My lord, so
After
that's
after
what-
1/4, where is the renewal?
My lord, the policy provides that, my lord.
I am asking you, 31st March it ended.
My lord,
It has been renewed.
it has been renewed, my lord.
Show me the renewal.
The renewal, my lords, will see at page.
Sir, you tell me your
Nine.
At page
Page
11,
nine.
my lords may see.
Page 9. 31st
Page
July
9, my lords, my lords,
2024.
page 9. Page 9.
Yes.
That has been, this is dated 24/24.
Where do I get it? Yes. No. That is the license is valid. It is granted on 30th of April.
April 24.
No, my lord, page 9, my lord, this is granted on 29th of April. And this is valid from 1/4/24 to 31/7/24.
Can you give a retrospective effect?
My lord, that is according to the, my lord, policy. My lords may kindly have the policy.
Sir,
My lords may see the policy.
I am understand. When you seal the shop, because they did not have the valid license to vend the liquor.
My lords,
They cannot vend the liquor.
my lords.
How can you give a license from a retrospective effect?
My lord,
That
the-
shows that during that period he had a right to sell.
Milords, if the license is already expired, my lord, the period of the license, my lord,
See,
the excise policy, my lords, may kindly.
When he's putting a question, I am simply asking him, I know that what you said. I am asking him just a counter that whether his stand is justified or not.
My lords, my lords, the excise policy of the year 2024-25, my lord, it speaks about advance consideration money for renewal of license. My lord. What it says, my lord, says advance consideration money of 3 months for the existing FL shops, so and so shops.
Sir, then you could have done it from the day when you renewed the license. That is from 29th of April for a period of 3 months.
Lords, I think, my lord, there is like a financial year, my lord. There is also, my lord,
So when you give it from a retrospective date, it means the date anterior to the grant of license, then in that event, one has to, because he was not permitted to sell.
But my lord, that is for his own latches, my lord. He had to apply 3 months prior to the last day of the expiring license. That is what the policy says, my lord. It was his duty.
Then why you have renewed the license?
On his application, when he made the license on 10th, my lord, we had to renew it, my lord, because he
Why?
deposited the fees also on 10th. Of
So-
course, belatedly, my lord.
So-
My lord, but then, my lord, we have to grant the license from April itself, because that is where the, my lord, the new fresh year starts, my lord.
Anyhow, yes, what you say, what is the ground for sealing?
Can you see why they have sealed my shop, my lord? That is in page 15. Commission of inquiry report into the petition filed by one Krishna Chandra Nayak of Harishandanapur.
Where from?
Page 15, man.
I am reading it. I am at
Subject, man.
subject. Okay. Hmm.
He made on the basis of the allegation of Krishna Chandra Nayak against illegal production and sale of liquor by the BH of Harishandanapur OHL shop in nearby area.
Correct.
For which, my lord, during course of inquiry, my shop was sealed. And after that, they found that the allegation made by the next one, last para I have reading, my lord.
They sealed when?
That it is reflected in paragraph 2, my lord.
No. It simply say prior to.
My lord.
That means prior to what? Means prior to 30th or on the sale hour, after the sale hour.
After the sale hour, dated funds.
So
After the
that
sale-
shows that the license was valid till 31st of March.
Man.
Thereafter, they put it under seal.
But on the basis of the allegation of that.
Whatever be the reasons, but your license was not renewed. Can you sell if the renewal has not taken effect? No, can't sell. No, brother, they can't. They say that after the sale hours, dated 31st, because that was the last day, that remained closed under seal. Because they put under seal because contemplation of renewal, they cannot continue selling it.
Even if it is retrospectively,
Maybe.
event is
Yes,
also.
for the- yes. With the rules, where are the
My lord,
rules?
have given the rules. My lord, the instruction along with that, my lord, will see after the instruction, the last 2 pages, my lord, 3 pages, that is the excise policy. Excise policy 2024-25. And at the foot of that page, my lord, for para number 13, advance consideration, shall be collected by 31/3/24. It is very specific. Advance consideration money of 3 months for the existing shops shall be collected by 31/3/2024 from those EP holders who have applied for renewal.
So it has to be paid by 31st.
By 31st, my lord.
It does not talk about the application to be made 3 months before.
No, my lords. The money for 3 months has to be made by 31st,
So
along with the application.
yes,
In my representation, I have stated that the shop was sealed from 31/3/24 to 29/4/24.
Because it was not renewed.
You also can see that page 30. The application for the period is 1/4/24 to 31/4/24.
But that was sanctioned
On 29th.
29th. Your license was made sanction on 29/4.
Sanction.
May be given a retrospective effect, but during that period, 1 to 28, you did not have the validity
Yes.
But
to have any
you must-
business activity in respect of this commodity.
Madam, page 13 also. Page 13. Application for the period. You must-
Yes. Merely because you have
The
made
writ
application
petition, the writ
unless
petition is taken out, seeking a direction from
High Court PIL rule, they should issue a notice to the government before filing PIL. No light of CCC. But they have not issued that notice. Perhaps they have filed that.
Section 80 notice.
In the light of Section 8.
It's like a section 80 of the CPC notice. I'm just talking about 2 months period to be given.
Here it is 30 days as per rule 8 of PIL. They have not annexed that notice to the reputation. Probably IAG.
Seeking exemption.
My lord, the communication is annexed, man. Rule 8 is compliant.
Show us. Show me the rule.
My lord, annexure 1 at page number 45. This is in compliance of Rule 8 of the PIL Rules 2008.
And when you have filed, it is 10/10.
Yes.
And when you have filed after a month, 30
Yes.
days,
24
2 weeks thereafter.
how can you file a shorter one?
Or I'll just read over Rule 8.
Oh, it's a reflection of section 80 CPC. I asked you section 80 notice. You said yes. Yeah, you said no. Rule 8.
Yes, ma'am. Rule 8.
Rule 8 talks about section 80 notice.
The akin to CPC, 80 CPC.
Yes, that is what is there.
So that they are aware, they are communicated, and in the absence of any action thereof. My lord, this application which is filed.
Where is a 30 days? I do not find.
There is no 30 days, man. There is only a prior notice to the state.
No. Akin to what is postulated means section 80 talks about 2 months.
In spirit, my lord, not in letters, my lord. 80 CPC has been referred in spirit. There is no. Otherwise, the High Court would have come up with the specification of the period. And there are PILs your lordships have indulged. My lord, your lordships have entertained PILs where there has been no communication in terms of PIL which are very, very excellent. Please see your last order, your lordship. Please, ma'am. The lordship's last order.
No, I understand.
Yes. There is a communication. After that, I have filed the PIL. And this, because the legislation.
What is this? This is a very important issue he's raising. So he says that if somebody is not really utilizing the resources to an optimum level, then why don't you take over? You take over. We are directing you to take over all these mines. You run.
On that aspect, I'm praying for short extension.
What is this extension? We do not think that it should go to any third party. Let the government utilize it. Let the government do it. You are the owner of the natural resources. You take over. I think you have some government companies are also there in the mining.
OMC, Odisha Mining Corporation is there.
You do it. Odisha Mining Corporation will run those mines.
And there is
it will help the government in all sense to have the full utilization of the natural resources. Why you will go for a private individual? Do it yourself. Do it.
For 10 days time.
What 10 days?
No. You have written letters to them.
What is this going on?
Only 7 days time.
And this is a serious issues which are left, because if they say that optimum, you have framed the policy of the rules.
Rules, Miller.
You have framed that the optimum, the production would be this. And it appears that most of them are not reaching to that optimum level. If I correct.
Not in 50%.
50%. 3%. And then you are simply imposing a penalty. If you are equipped to do it yourself. Let the government do it. What is the difficulty?
Take up this matter next week.
This cannot be because had it been that somebody else, here we are giving it to the government. You will be more enriched on that. Next week on Monday. Let them, otherwise.
But in the meantime, let them, that interim application I have made, then let them give a list of all of them, those who have been lacking behind.
Copy, sir.
No, copies, sir.
Copies, sir.
Go.
Copies, sir. Advance copies, sir. I cannot file other.
Find out.
Not available.
Mr. Counsel, Mr. Counsel,
My lord.
he is requesting.
My lord, I'll do that. I'll do that.
17.
Item 16.
You have to come with a positive mind. What you will do.
Make feel. Just now on the counter shot on me.
No, this is writ appeal.
Yes, I'm appearing on behalf of the opposite party number 6, who was the writ petitioner in the court below.
You are for the respondent. You are for the respondent.
Yes.
Number
What do you want?
My lord, next week, any day.
Thursday next.
17.
A copy of the counter affidavit is received by the counsel appearing for the appellant in court today. And he pays for an accommodation to peruse the same. So this is a matter of such.
It was all argued, I think.
Yes.
If you see that tender matter, on compliance of essential term, the NG project was running against us. Thereafter, that judgment of the Honorable Supreme Court, we cited that the ratio is watered down in the Jai Bholenath's case. And your lordship will be taking note of all previous judgments like Vidarbha and AF Enterprises, all previous judgments. Once essential condition is not satisfied, the bid to be rejected. But that
Bid to be?
Bid is to, the technical bid is to be rejected. But that is not also, the other side also said that yes, there is non-compliance of essential term.
So what do you mean? The essential terms and conditions which are there, if there is a lacking, then it is to be cancelled. He says that other side has also admitted, yes, there is a lacking.
Did not admit. Did not
It's for orders today. That day he could not explain, could not say that it is admitted that it's violated. He said to that extent. Of course, if he today is saying that it's not violated, then I can take your lordship to that.
Was hearing me and then lordship is.
No. What he says is that on the other day you admitted, so there was no occasion of any further hearing. What he says is that if today you recite from the stand and say, no, I have not admitted, then he wanted to place it that this is what the violation is, then you respond.
No, it was all argued.
This is what he wants to say.
I did not admit. Never admitted.
Anyhow, we do not intend to go into this aspect. It's an embarrassing for the member of the bar.
Wrong statement because my learned friend is appealing for an organization. If he admits, then he will be in trouble. So I should withdraw that statement.
Yes, give me 5.
Page 23, your lordship could kindly note. But just to remind you, this is about the cleaning of the overhead drinking water tank.
Oh, yes, now I remember.
That is the matter.
Page?
Page 23.
20?
23. Yes. Page 23, your lordship will find the nomenclature of the tender. Cleaning of overhead water tanks.
Yes.
Of residential and non-residential fishing and underground reservoir in Alconagar source. Yeah. Now, your lordship.
Okay, or experience, expertise or.
No, there are 3 categories on the parameter of the amount.
Evaluation.
When you said that all are different, then only accept this, which falls below.
Below.
If now I correctly
Yes,
remember.
and that too, cleaning up sludges, cleaning up sludges, not water tanks. That is the experience certificate. Your Lordship would see the experience only and the experience certificate given by him.
Yes.
Page 71, your Lordship would can.
That will give you right.
The requirement is at page 71.
Just take a
Page
photo
71.
of pages. Should I mark those pages? Huh? Take this one.
Should have experience of having successfully completed similar.
That I've signed 8.68 lakhs, 10.85 or 17.36.
Right.
And the cleaning, similar work has been defined.
Yes, sir.
Overhead tank and
Yes.
undervoid reservoir.
Similar work means cleaning up overhead tank, underground reservoir and mechanical means. Then it is with regard to drinking water. This whole work is for drinking water. Page 79. Just to remind my lords, nothing beyond that. Just to
I'm
remind.
just putting this.
Page 79.
I'll search it out. You just put it.
Yes. 2.1 and 2.2.
Correct, your lordship must
Yes.
have marked it. Then your lordship would stay to and take your lordship to his experience certificate. 1 second.
Page.
Page 234, your lordship would carry. The experience certificate he has given is
234
yes, 234. This is the experience certificate.
or 236. Oh, 234.
Right. This is the certificate.
Maintenance of the wastewater treatment plant.
Yes. Then your lordship kindly turn to page 236. What is exactly the experience he has given is mechanized cleaning up sedimented sludge. Valuation is 57,580.
Yes.
Whereas the requirement is something more than.
Yes. Yes.
Then exactly your lordship will find page 240. Mechanized serial number 23. Mechanized cleaning up sedimented sludge. Mechanized cleaning up sedimented sludge deposited in zero discharge also.
240.
240. Serial number 23.
Serial number
23. Sedimented sludge, that to valuation is 57,000. Whereas the requirement is starts from 8 lakhs.
Yes.
17 lakhs.
Mechanized cleaning of the
Mechanized cleaning of sedimented sludge.
yes.
Sludge
Deposited.
deposited in zero discharge. Some pit with all machine tools, lacquers, level.
Yes, there is not concern with the overhead water tank. Yes, or underground reservoir. Yes.
Drinking water. This is all I know. And
Yes.
I've given the compilation of judgments.
And where is the essential terms and conditions? You just show us. Page 30.
30, yes. Page 30. Clause 5.1 and 5.2.
5.1.
The evaluation.
Yes.
Evaluation will be done strictly in line with.
Yes,
It
yes.
is available on.
Yes, then let us hear him.
Right.
PQC. PQC.
Pre-qualifying.
Pre-qualifying conditions. 71 is a pre-qualifying conditions. Yes, 71 is a pre-qualifying criteria. And this is PQC.
Worship, page 71B, last criteria is one similar work completed or partially completed work, executed value not less than 70.3 lakhs.
Correct.
And similar work is cleaning of overhead tank or underground.
No,
reservoir.
page 71 does not talk about 3 lakhs.
No, not 3 lakhs, 17.3.
Yes.
Because
If it is only one work.
one work. Here admittedly submitted one work order in
So-
support of that. And the similar work is, Lordship may see the second.
At the bottom.
Second last paragraph, similar work means cleaning of overhead tank
So,
or underground reservoir.
correct.
So
So,
at page 234, the work order which he had given, the total work order value was for 32 lakhs.
can
But-
it be because it is similar work means be cleaning of the overhead tank and this. So he has not given it for overhead tank. That is a page
236.
234 and 236. Yes,
236.
correct.
236.
Show us.
I'll finally submit that only serial number 23 was the similar work.
Absolutely.
That was the similar work.
So,
Because that related to underground reservoir.
correct.
But what we have done is, because this work order was also issued by us, because earlier in all work orders, we were never issuing a separate work order for this work. So for this, since we were issuing combined work orders, that's why we have considered this, because the total executed
So
value.
you
of
could
the
have,
work
you
order-
could have defined, you could have defined
We should have
as a
defined-
similar work. When you define the similar work only in respect of a overhead tech, then how can you cannot resign from your own conditions. You can't.
And so that I'm fairly
That
certain.
is-
Only
that's-
serial number 23 was the.
Then whether
And
it's
only
not-
one more aspect.
Whatever is there, we have to submit this for.
More than 18 months of the work has been executed.
So whatever.
36 out of 36 months, 18 months work has been executed.
Protected by an interim order, subject to result of the petition is there.
Yeah, for the
Yeah,
rest of
you
the
are,
period.
you are for responding number 2, opposite party number 2.
Mention paragraph of Vidarbha.
Vidarbha will compilation.
Yes,
You could kindly turn to paragraph 14 and 16.
14 to 16. Oh, you have given.
I have given the compilation.
AF, what, 11 to 23.
Right.
Aparna is 15 and Sachin is
So I will
16.
paragraph with reference to page number. Aparna Sahu, Sachin Agarwal. These are all judgments of our High Court. Then Jai Bholenath, who is distinguishes the NG projects, Devita Kamat are given.
Yes.
Yes,
Next
If
week.
I can give a latest judgment. Bhagat.
Next week.
Then
Please use for opposite party number 2.
the latest judgment I can, subject to lordship permits me, I can give a
You want to
latest.
say anything?
What
You want to
is
say
this?
anything?
Same thing, but essential top, para 29.
Para?
Para 29. 29 and 50.
Yes. Give a date no? When. Give a date, brother. Yes.
For orders item 18.
Matter was, it was my lord, was. When my lord was. Is to see the order.
The lordship had called me and asked for, I have taken instruction and filed a short counter to bring in notice the subsequent event.
Subsequent event, my lord, what has happened?
May I?
May I-
EIP has already been
please wait
filed.
for a minute.
The question is, sir, the jurisdiction. We are more concerned with the jurisdiction.
Yes, ma'am.
Can an order passed by the civil court
Yeah.
is amenable to be interfered with under Article 226 of the Constitution?
But we usually file CNP.
So, sir, whatever, I can understand Article 227 can be invoked
Yeah.
to that extent because the law is very clear in this regard. That 227 is a power of superintendence, meaning thereby that the High Court will keep the district courts within the proceedings of law,
Right.
not allowed to cross the boundaries of law. To that extent, I understand.
Right.
226.
But if I may fairly.
If there is a notable decision of the Supreme Court in 2003,
Right.
clearly defining a line of distinction between 226 and 227.
Completely pardon. Well, my humble submission is in this order, they are agreed by a interim order.
In the meantime,
order,
I understand, my lord, I may allowed to be.
I am more on a jurisdiction, just
I
on a
absolutely got it.
jurisdiction point.
My humble submission is.
We will not enter into the merit.
No, my lord, I'm not in the middle. I'm saying, my lord, this order has become academic, my humble submission. In the meantime, FAO has been preferred before the district judge Katak, my lord. At that point of time, district judge was not available. In the meantime,
I think the office is there, the seat is there. There is no difficulty
No, no, I
in
completely-
filing an appeal, provided even if the district judge is not posted, there is somebody who discharges the duties and functions of the district judge.
that is why it was not done.
Filing is not a.
No, my lord,
there
it
is
has
no
already been
fetter.
filed. FAO was filed.
So
Because of its absence, because they were not taken up, we filed a CMP, my lord. CMP order is already there. So I'll bring those two on record, my lord.
what is so why this order or this writ petition should be kept pending?
This
Why?
petition is not pending.
Means whatever the order which is passed will not remain on occupy the space of the
My
judicial.
respectful submission is not, my lord, because now CMP order is.
Then we set aside this order. If the CMP is there, they will go.
My lord, my entire thing is, my lord, now.
It has to be, it needs to be deleted. 7.
True.
Up to 7 it is okay.
Paragraph 8, yes, it has to go.
Yes, ma'am.
My lord,
It cannot stand in the way.
my lord, may I only bring those two and record, my lord? The lordship can-
We do not want. Why we will go?
Up to para 7 it's okay.
My lord,
If petition is,
Allowed to be withdrawn.
my lord.
that's all.
How the subsequent order be passed? Interim order.
Well, my only addition maybe for your respectful consideration, madam, is that madam may kindly note that the FAO pending before the district judge, they may not be that may be decided irrespective of all these orders, madam. That may be decided.
That is the law.
Well, that is reiterated, madam.
Why something is you want some blessings? We will simply say that it
No,
is
but-
not permissible.
I'm humble, sir. Madam, I will not take any advantage. They will take an advantage.
No, nobody. It is immaterial before us whether he will take an advantage or you will take an advantage. There cannot be an order of such nature. Cannot go. Cannot.
Even Madan Gopal Rumta, if we.
That's a very important judgment. Madan Gopal Rungta. I think that originates from this court.
Yes. From this, 1950.
Old judgment, 5 judgments decision.
We can only clarify the facts. Actually, my lord, what had happened.
So we simply want.
No, no,
No further order.
No, no, I'm only-
After this.
No, I'm only stating the fact. My lord, if I may.
Sorry, we can't. It is really very, it is a disturbing state of affairs. There you just see C. Yes, next.
Item 19.
My submission will be recorded that in the meantime, CMP and FDO will
Why you are getting last paragraph has taken care of that. What more?
Should ask me to appear today, so it's
No.
only prayer.
I have not recorded the submission of anyone. Yes, go ahead.
Item 19.
Item 19. Requested me that he is not leaving.
Why you have come? Then why you are here?
Some other.
Don't you have any friend or a junior?
Because from morning I have getting some.
So you could have sent any junior or a member. Why you are sitting and waiting for the matter? Go home and take rest. Take the doctor advice. Next week or a week thereafter. Next week or a week thereafter, tell me.
So just a simple prayer only. That let a date fixed so that on that day.
Sir, we are asking what you understand. I say next week or a week thereafter. Tell me.
Any date will be fixed after 2 weeks. And that
After
day,
2 weeks. So fix a date. After 2 weeks, tell him.
So
3rd December.
that we will be allowed to file the written after that day.
3rd December. Come.
Item 20.
Give me the. Oh.
Another 48. And Lawrence Senior is arguing from the outside. The argument that day I was absent. My associate is present in the court and noted, then I can assist the court. Item 48.
Railway siding construction.
Railway siding construction matter.
Oh,
Against the order of the enrolled single judge, then had it.
The petitioner has already
Complete the argument. There we are advancing. Yes. So Lordship fixed it 2 p.m. and ready, my lord, but then
it was already argued, I think.
Yes, completed the argument.
Argument by the appellant.
Only mistake. I want to prepare written note of submission. I could not have done it. If Lordship fixes any tomorrow or day after or next week any day, then I will come to it.
You prepare next week. We'll take care.
Next week, yes. I will oblige, my lord. Yes.
Wednesday, 19.
First.
We may reach today also.
No, if Lordship, another partner matter is in, that's why I am requesting. If my lord will accommodate, then authorize, I will help.
Item 21.
Oblige.
My lord, in that matter, sorry, my lord. And submitting the compilation of the judgments we have referred to, specifying the paragraphs there with an index.
Let them serve a copy also. We can review it. What a citation is my refer. If you give me the reference, then I can.
At 2 p.m. minus?
Thursday at 2 p.m.
Only their argument is left.
Let us take them to
Published.
come at 5 p.m.
Published.
3 p.m. Yes.
21.
The first matter. There are 4 petitions. In the first matter, that happened in this case, the pursuant to auction notice, petitioner participated in the bid and declared a second highest bidder. Second highest bidder. First highest bidder refused to accept the bid. That's why letter of acceptance was issued in my favor. I deposited the entire cost and obtained the mining plan and also environment clearance, and I deposited the entire amount. On the day of execution of lease deed, a communication was made from the Advocate General Office. A repetition is pending in respect of same Sadat. That's why my execution of lease deed has been not executed.
This is put in abeyance.
Yes, ma'am. That is that writ petition is number.
Why 4 writ petitions?
How many writ petitions?
I'm clarifying that. But
One, two,
yes, ma'am.
three, four.
Well, his bid was rejected on the ground submission of false affidavit.
Whose bid was rejected?
But one Bhimasan Dole, whose writ petition is,
You are appearing for Vipasan Jalai.
yes.
I am that you are the second highest bidder.
One.
Correct.
Yes.
That means it was not rejected.
No, my bid was not rejected. I was.
Who are you? Bhimasen? Who are you? Bhimasen?
I am for Bhimasan.
Bhimas.
One.
So your bid one, you say L1 has refused or H1 has refused.
Yes.
So you have been awarded, you have deposited the money, you were going to execute the agreement at that juncture.
Well,
The advocate office has
issued a letter like that.
there is a writ petition pending in respect of this.
Self-consultant.
Right. And then what? Then what is your grievance? I understand that you should be permitted to execute. They should execute. I understand.
Yes.
What is the second? This Krupa Sindhu Madhuri.
So that writ petition is 36487. Due to pendence of that writ petition, blood.
Pendency of that means what? This.
Yes.
Say this.
This writ petition.
That create the confusion. What that?
Yes, sorry.
This writ petition.
This writ petition, blood. Execution has been
Has
done.
been stopped. Here there is any interim order passed. In this writ petition, any interim order is passed.
I think, Lord, no. 36487. No information.
36487.
P1.
12305.
Last item, is a for WPC number 36487. Last writ petition, there are 4 writ petitions. First and last are connected. For same soil. For which
Now it is passed in 36487.
Well,
Correct. Now, what is the challenge in 36487?
rejection of.
Who is he? He's a H1 or what?
No, his bid was rejected on the ground for submission of false affidavit.
Okay.
That rejection is impugned in the writ petition 36487.
Correct. And what is the interim order passed?
In that writ petition, well, I don't think any.
Any interim order is passed, there no. And what is the other? 123 05.
In that case, I am the petitioner.
In
my
case also you are the petitioner. All the
Yes, connected in sense,
12305 is what?
My lease was extended for 3 years, 2 years, and it was rejected. The consular should execute the lease deed, but he didn't execute. For which I came to this report, in
the auction of the seal.
No. Other source, other source,
So it is not connected with.
Correct. I'm saying just temporarily.
Then why
he rejected later he cancelled the lease deed on the ground that I'm a defaulter,
So then why?
But I'm not a defaulter,
That means it is an independent requisition unconnected with his case.
Because
Because it is not related.
my bid was rejected. No, my bid was rejected in that case, that his case.
Right. So
On the ground that I'm a defaulter here.
That means 3178 of 2022 by him should be heard only with 36487. Other two matters are different.
Yes. Not different.
Because it does not pertain to same side.
In sense, just I'm saying that. But they say they rejected my bid on the ground that I am a defaulter in that source which I have challenged in those cases, in these cases.
Sir, that you have already challenged in 36487.
My lord, I have challenged.
So why this petition is filed?
Another source, they rejected my bid on the ground that you are defaulter in that source
which is 305 minutes. Why it is connected with this SIDR? It's a different SIDR. My lord. So why it is connected? So we will hear differently. We will decide one. So we will hear one this 3178 and 36487 together. My lord. So you argue 36487. One. But my bid has been rejected, Lord, in 487 million. 36487. This is what I on the ground. On this. Sir, on the ground that you have defaulted in other source, Lord, which is the other two cases, Lord. Unless that is decided whether I am defaulted or not, Lord, it will prejudice me, Lord. That is why the other two cases, Lord. It has to be decided whether I am defaulted or not, Lord. In that case, they have admitted that I am not defaulted, Lord. But here they say you are defaulted. That's why, Lord, I am saying 305 and 78 as Lord. Yes. In the file of 364.
Last.
It's for the state.
I am for this.
In those cases where state was directed to file an affidavit regarding a cancellation, receipt of cancellation. They had cancelled, but they had not intimated me, Lords. They had cancelled my lease date, but they had not intimated me, Lords. In 36487, there is the order of rejection. Next up for page 193. 193. This is a court of sub-collector. My lord. Appeal order rule 46 of the OMC rules. Yes. 600. This is an appeal order, appellate court order. Your Saira is Rajpura.
Yes, sir. You are challenging this order. Annexure 4. You are challenging this order. What is the grounds? What grounds you are challenging?
I'm very sorry, my lord, I have not brought that. I'm very sorry, my lord.
What?
I have come with other brief, my lord, I have brought that. I'm sorry, my lord, only tomorrow is also. I'm not, tomorrow, my lord,
All these matters are listed. All the four matters.
other cases I have that matter. Only brief I have. No, so tomorrow, my lord, tomorrow, I'm sorry. In black, only I have not, I have brought others. All the like, only that person. I think. Well, folks, it is one. I'm sitting idle, investing heavy amount. Since 2021, I'm sitting idle. Rule 27 4 is very clear. A false affidavit has been filed. As between both the writ petition, they have challenged the demand notice. And they filed an affidavit stating that there is no demand. Here in the connected to writ petition.
At least from the appellate authorities order, I do not find this fact. What you are saying. I find a different fact.
Yes, but only extent.
Only thing is that he has not committed and there is a dues.
Demand.
There is a demand, means the dues against him.
Again, rule said, my lord, at the time of submission of bid, all intending bidder has to file an affidavit. There is no outstanding binding dues. They have filed that affidavit.
We have to just take
Correct.
into consideration.
Correct.
There are various factors that when he submitted his bid, when there was a demand raised, all these factors, the date has to be considered. If the demand is subsequent to the submission of his bid, then on that day, at least
Correct, man,
there was
correct.
no demand. So no
Yes,
dues.
correct, man. But prior to that, demand or prior to.
Whatever, we have to then go into that aspect.
Correct, man.
Let us see. He's saying, let my brother fix a date. Yes.
19. Constant.
Immediately. 19. Well,
Yes.
All the force because it is connected to the.
Item 22.
19 you
Yes. 19.
I think 22, your lordship. I filed an IA for intervention, your lordship. Matter food and speech therapy for the 166 disabled students, your lordship. 166 disabled students, they have been stopped from providing.
What do you mean by disabled?
Especially able. Especially able. So I have filed an IA, your lordship, for intervention.
Who are you?
I am also student and some of them are the students and some of them the guardians of the student of the.
Why you want it? Your interest has already been taken.
No, your lordship, interest has not been taken. That I will answer if my IA is allowed. Because in the meantime, that petitioner, the main petitioner has died also. That is no major issue, your lordship. So that I cannot answer.
Petitioner means.
Dinabandhu Samant, the main petitioner, the sole petitioner.
So then right to so far as to survive.
Your lordship, it is about more than 100.
Then if he is dead, then it has abated.
I do.
So if it is abated, then how intervening application can be? In a dead proceeding, how can it be? No. No, it cannot. When he died. When he died.
Exactly 6 months back. Not aware. I don't think so.
When he died.
It is about 6 months back, Your Lordship. 6 months.
So 90 days period.
Your Lordship.
Here I do not know.
Your Lordship was 16 months and exactly his death certificate.
Even if it is a writ proceeding, it is not a suit, then also the residuary clause. What?
Your Lordship, liberty may be granted to file a fresh with the present petitioner because where the main grievance has not been answered, Your Lordship. That is the main problem. Grievance has not been answered. That's why I have filed for this intervention, Your Lordship.
Now the counsel who appeared for the Mr.
This was the question.
When you call Mr. Dilipur Mahapatro,
I don't have his contact number, Your Lordship.
Afras Suhel.
Your Lordship, I'm Afras Suhel.
Oh. And who is P. Behra?
He's actually the associate of this. I don't have their contact number, Your Lordship.
Are they not the member of the bar?
I will give, the adjournment may be given, I may be contacting.
To please contact me.
Your Lordship.
Sorry.
Yes. Well,
Item number 23.
In this case, the petitioner who was operating an IFL offshore minor has filed this writ application challenging the demand notice, which has been raised for the year 1989 and 90 after 22 years of closure, after 22 years, which is not.
Was it 8 and 9?
98 and 99 minor.
Or 98 and 99?
On the basis of the audit report minor, which is not viable on the plea that the.
When you closed?
I have closed in 21 minor. As per the rules, my lord, the MGQ has to be lifted every month, my lord, failing of which he has to pay the in the next month, and in his failure, the same shall be adjusted from the secure deposit, my lord. If he has not paid the duty, any duty has
I have
been
already released the security deposit.
My lord.
21?
21, my lord, that has been.
Oh,
That has been
deposit is with them.
With for the 3 months, my lord. At the time of the renewal of the license, so we have to pay 3 months license fee, my lord. That shall be adjusted at the time of expiry of the license, my lord. If I am unable to pay as per the rules, my lord, the MGQ has to be lifted every month, my lord. In case of failure of lifting any part of the MGQ, my lord, and the duty charges shall be recovered from the 3 months secure deposit in the next month.
Renewing it, they never charge for 98, 99. That is your case.
My lord, in similar type of matter has already been decided that since the matter has already been held after 22 years, and this is not viable since the license has, at the time of renewal of the license for every year, you have to pay the area dues. If the area dues has not been paid, then your license will not be renewed, my lord.
That's why I'm asking.
My lord.
Since the renewal has already taken effect, so it implies that there was no duty.
No dues, my lord. Similar type of matter has already been decided, issued by the same authority for the same year, my lord.
Yes.
My lord, I'm
Over
aware of that judgment. My lord, I have terms to that judgment. I also have a copy.
I have also supplied the.
Yes. Yes. Give me that the relevant rules.
My lord. Rule 45, in this case, another point I have raised, my lord. My lord, I have annexure, at annexure, my lord, 7. Rule 6 of the Orissa excise rule says that the MGQ shall be, monthly MGQ shall be at page, my lord, 19, my lord.
Sir, show me the provision.
My lord. My lord, rules provide that the licenses shall leave the monthly MGQ guaranteed against the every month.
Sir, I am asking you, show me the rules relating to the clause.
This rule, my lord, provides that.
Which one? Rule what?
My lord, rule, my lord, at page 19, my lord, excise rule, minimum guaranteed quantity shall be released, my lord. 6(2), my lord, clause 2.
6 clause
2. The licenses shall leave the monthly minimum guaranteed quantity equally approved for that month and left unleft. If any by 30 p.m. the last working day of the month shall be forfeited. Last. Yes. Answer 89, my lord. That has been annexed, my lord. I have annexed the sales. It is a old rule, my lord. Bihar and Orissa Excise Act that prevalent. I have annexed that rule, my lord, at page 19, starting from 17, my lord. That is the Orissa Excise exclusive privilege currently government 18. Period 90, 89, 99. For the period of 98, 99. Duty. Short run MGQ, my lord. Duty charges I get the short run MGQ for the year 98, 99. I have annexed that rule in Annex 7, which clearly that the MGQ shall be lifted every month, my lord. Telling which the license shall not be renewed, my lord. Secure. It says actually.
About the Orissa excise rules of 2017.
17, my lord, that is also said, my lord. You have to pay the leave the MGQ, monthly MGQ by every month, my lord. Telling which
Just when you say that, I just wanted a renewal clause in the Orissa excise rules.
You renew the license.
It's usually provided under the liquor excise policy norms. The policy that provides the procedure for renewal. Like in the other case that I was showing today, in the policy bill, it was
Yearly renewal. It has been made on rarely each year renewal basis. That was been earlier.
Because the act, not the rules contains anything about renewal.
No, that's apparently because I also because there is a provision for renewal on the death of a licensee, but that is
a transfer of the license. 45. In case of the transfer of the licensee, he has to, in this case also, this license, the original licensee had died. Subsequently, that license has been transferred in favor of the another person. As per the rule 45, my lord, the
other person means son or a daughter.
grandfather, my lord. Initially, the license was granted in favor of his grandfather. I have also quoted in my petition.
No, sir, why I am saying
My
what
lord,
troubles me is section 109 of the act. Because I find the rule which you are now referring, that rule is framed in exercise of the rule-making power from Bihar and Odisha Act 2 of 1950. Now this has been repealed. Once the Parent Act is repealed.
This demand notice for the year 1989-99, my lord.
2017.
My lord, in that particular period,
demand is raised after 2017.
At that particular time, my lord, if he is unable.
Why I am asking whether this rule will have its applicability.
No, sir. Present rule may not be applicable since the demand notice for the year 99, my lord.
The rules which include,
My lord.
one of the rules is that it can be demanded or recovered
My lord.
as areas of land.
Land revenue, my lord. As per the OPDR Act, if that demand notice has not been raised within 10 years, it became barred by limitation, my lord.
When you take a provision of taking a benefit of the provision of these rules, then first thing is the validity or the lifespan of the rule has to be considered. And this rule which you are referring, this was rule framed to Bihar and Odisha Act, which is repealed in 2017. If the Parent Act is repealed, whether this rule will survive automatically or it will also perish with it.
It's the matter pertaining to that particular area prior to amendment, my lord. My view is that this rule regarding the procedure in the recovery of the dues shall be prevailed.
How?
Yes, my lord.
How?
My lord. As per the rule, my lord, 89 rules, he has to pay every renewal, every year renewal, my lord. As per the renewal, my lord. If he has not paid the area dues, his license must have not been renewed.
I understand, but this 89 rule is framed. The rule is a subordinate legislation. The power in the Parent Act must be there. If the Parent Act has died, then what will happen to the rule, subordinate legislation? Tell me. What would happen?
If in this rule provide that if the dues has not been paid, my lord, in due period monthly, every month that license will be cancelled, my lord.
Probably I am unable to convey what is passing in my mind.
Regarding the recovery of those.
Sir, I never said so.
Regarding the renewal of the license.
So which provision?
Item 24.
Lordship, item number 24, may I please the Lordship? On behalf of Mr. Mahapatra, actually he is severely ill. So I may be permitted with a week time, Your Lordship. The same is communicated to the counsel for the petitioner as well, Your Lordship.
What?
OP number 8, Your Lordship.
The ground that we
And it's 1 week time.
very seriously. We do not know. Can you presume even without a maybe after if you're friend in the bar.
Yes, madam.
Item 25.
Right.
Written note of submission, my lord, already. Commissioner written submission. This is my lord. The agreement for transportation of mechanical transportation of crossed coal by tippers. Madam, I was awarded with this work. I commenced the work in 4/7/2012. Then I completed the work in 3/7/2013. After my lord, in 2023, impugned order, my lord, they have imposed a penalty of 12 lakhs, my lord, on me. Without any show cause, without giving me any opportunity of hearing.
Sir, come back. Debate को lose उसका नुकसान.
Problem. No, it was screen got blank. No, now it has come.
Yes. Topic high.
So without.
Yes, ma'am. My lord, what has happened, my lord, in the contract, my lord, there is a provision, my lord, whenever it's a, whenever there is a,
solution
Yes, yes.
in the contract terms and conditions, my lord, 6.2, it clearly entails us that if there is any shortfall, my lord, in transportation, otherwise then a penalty will be imposed immediately, or you will be given a chance to improve upon that transportation to mitigate that shortfall. My lord, nothing was done in between the currency of the agreement or the contract. After 2023, suddenly they are imposing this impugned order saying that you have to pay a shortfall penalty of 12 lakhs has been imposed on me. After 10 years, my lord.
After 10 years.
Yes, my lord. Work was completed, my lord, way back in 2013. 2023, this letter has come. This demand letter.
All the payments were already made. Transportation charges.
Everything was done, my lord. Everything was done. My lord may see page 39 for a moment.
Yes.
My lord, this is issued by Mahanadi Coalfields Limited, Office of Project Officer Jagannath Colliery, time-bound program. The name of work is Mechanical Transportation of Coast Coal by tippers from feeder breakers of Jagannath Colliery to siding number 1, 3, and 5 of Jagannath Colliery area for a period of 1 year.
NIT 653. Thereafter, my lord, date of commencement of work is 4/7/2012 and completion of work is 3/7/2013. It has been signed by the assistant manager, contractor, and project officer. So when the work was completed way back in 2013, they suddenly, my lord, page 12 is the impugned order. Page 12, my lord. Annexure 1.
Yes.
In this, they have given this revised estimate, closure of contract. They want to close for the closure of contract, my lord. Suddenly they come up, my lord, the second paragraph. My lord, first may see in reference to the approved number dated 33/2023, the general manager, this is to convey that approval of competent authority for revised estimate of executing 23 lakhs 51,000 metric ton for a period of from 4/7/2012 to 26/10/2023. They have written some typography, my lord, for a total executed value of 3 crores 51 lakhs. My lord, thereafter.
Proposing for the first time is 12/11.
Yes, my lord. Then, my lord, they have communicated the shortfall penalty is 4 lakhs approved by. Yes,
I have read the whole.
Yes, thereafter final, my lord. This is after 10 years, my lord, they are imposing without giving me any so cause or anything, my lord. My lord may see clause 6.2 at page 65. This is the contract terms and conditions, general terms and conditions of the law. In the event of contractor's failure to comply with the required progress in terms of agreed time.
Where you are reading?
My lord, 6.2, page 65, my lord.
Yes, in the event, yes.
Yes, my lord. In the event the contractor failure to comply with the required progress in terms of the agreed time and progress chart or to complete the work and clear the site on or before the date of completion of the contract or extended date of completion, he shall without prejudice to any right or remedy available under the law to the company on account of such breach shall become liable to pay the penalty as under. If the average daily progress of the work during the calendar month is less than the stipulated rate indicated in the detailed tender notice, penalty as detailed below will be levied. If the average daily progress of work executed during the calendar month is more than 80% and less than 100% stipulated rate of progress, penalty equal to 10% of the contract value of the shortfall in work shall be levied. If the average daily progress of the work executed during the calendar month is less. Thereafter, my lord.
Means that it has to be locked out on a monthly basis and within 3 months.
Yes,
will have to pay.
Yes, ma'am. Now, my lord, in the counter affidavit.
Yes.
In the counter affidavit, my lord, what they have not done in the impugned order, they have not given any particular reasons. Now, in the counter affidavit, they want to improve on the reasons that was assigned in the impugned letter. They are improving, my lord, and that cannot be done because once you have given an impugned letter and you have not given any reasons, when filing an affidavit, you cannot improve upon the reasons.
Yes. Yes. You are appealing for
the petitioner, madam, for the contract.
You are for
MCL, madam.
you wanted us to read 300 or 400 pages of your short notes.
No, I have not given a short note of 300 pages. No, my lord. I have, no, my lord, that's not mine. I have just.
Opposite party number 1 to 4.
My lord, it is only for 8 pages, my lord.
Also,
My lord, I am holding my written note of.
9 pages only.
Mine is also.
No. If it is not short notes, then thereafter the judgments are more.
I have not
You
made
want to rely.
Yes.
So,
Judgments I have.
Lord, may I only. May I
Only two
clarify
judgments
what
I have given.
yes.
My lord. My lord, the same page which my learned friend took your lordship to, page 39. That is, it doesn't, it shows the completion date, but by that time it was not complete. It is signed on 2012. It is at the commencement of work. It is a time-bound program, and that only certifies that. Your lordship may see there is a signature which says it is signed on 2012. So 2013 had not occurred by that. So my lord, this document will not come to his aid to.
Sir, I understand.
My lord, now.
We noticed this.
Yes, madam. Now, my lord.
The question is very simple. You have said that there was a short.
Yes, madam.
Now you detected it after 10 years.
No, my lord. I'll show.
12/11/2023 is the letter of demand raised by you. And whereas the completion is of 2013.
Madam.
Suppose you have extended it. You may have completed in 2014.
I'll just show your lordship.
And then you made the entire payment. Have you not made the entire
Yes, no, my lord. In fact, I had not made the entire payment. There were 3 lakh shortfall. I show your lordship. My lord, in 2012. Yes, my lord. In 2012, he came before this honorable court. The writ petition was pending up to 2019, my lord, at his behest, and there was an interim order, my lord. So, my lord, till then, we stayed our hands off the entire thing, so we could not have done. Now, my lord, yes, he withdrew finally. So, my lord, now what has happened? That it is without opportunity of hearing may not be a correct statement, my lord. To the extent, your lordship may see my counter affidavit. My lord, there are 2 things here. One is a price fall clause and another is a shortfall penalty. Now, my lord, shortfall penalty, which my learned friend showed, that it is to be calculated every month. Your lordship may see there is a provision for hindrance register. My lord, it is at page 66 of the brief. A hindrance register. My lord.
Yes, yes, yes.
A hindrance register shall be maintained by both the company and the contractor at the site for recording various hindrances as mentioned above encountered during the course of execution. Now, my lord, that extract of the hindrance register is at Annexer B by 3 series. Your lordship may see their reasons for the shortfall has been written each day, signed by each party. Where it is on account of the department, huge quantity has been left out from being charged with shortfall penalty when it is attributable to the department. Only when the hindrance is attributable to him, it is that period for which that shortfall penalty is calculated. May I take your lordship to page 102 of the brief?
Yes.
It is what your lordship may see the first, second, third, 5th column and 6th column. Shortfall penalty due to contractor's fault, and the next column is shortfall due other than contractor.
Which?
Page 102.
Yes.
Column 6. Shortfall due to column 6. 5. I'm sorry, 5 and 6. Column 5 and 6. At the top.
There is no column, that's why I'm asking.
I'm sorry. Internal page 17 of my counter. I'm sorry, I stand corrected. Internal page 17. It is maybe a pagination defect. My lord, may see the 5th column.
Is counter
Yes. 17. Yes.
The column number is not given.
No, my lord, I have just calculated, but just to aid your lordship.
Target Then actual execution and which column?
Shortfall due to contractor's fault.
Contractor's column.
That is 5 from left.
Yes.
5 and 6. Your lordship may see to the last total is the quantity. For the shortfall which is other than contractor's fault, we have never deducted any amount, and you will also may see where it is attributable to him. It is every day recorded, my lord. So he had noticed each day what is the shortfall.
How he noticed?
My lord, because it is jointly maintained by the contractor and the. I showed your lordship the site. What is a hindrance register? It is at page 66. I will read it for your lordship again. A hindrance register shall be maintained by the company and contractor at the site to record various hindrances as mentioned above encountered during the course of execution. So, my lord, each day this is maintained, signed and maintained by both the contractor as well as the MCL. And your lordship may see that impugned order itself. 66. My lord, page 66 at the top. A hindrance register, it starts. So, my lord, it is to be jointly recorded, maintained, and that has been done. Each day he had the idea what is the shortfall and what is the reason. So, now, my lord, your lordship, may I take your lordship to the impugned order itself?
What impugned order?
Which is under challenge.
It's not an order.
I'm sorry, it's a contract closure document, my lord. Page 12.
Of?
Page 12 of the brief. The writ petition, my lord. Yes, ma'am.
Yes.
My lord may see A, B table I am leaving out just below the third table from the top. Executed amount of executed quantity, amount to be paid is 351. Amount already paid 348. What is recoverable is only a meager amount, my lord, 330. So, my lord, by this time, a majority of the shortfall penalty had already been recovered. He never challenged that. So, my lord, I stop here and take your lordship to what is the other ground for deduction? Price fall.
This is payable or recoverable.
Yes, my lord.
So amount to be paid is this, amount already paid means we have already deducted.
Yes, my lord.
Then?
So majority of the amount to deducted already, well. So, my lord, the other ground price fall penalty that is there in, may I take your lordship to the tender condition, which is at page 5.8a. I'm sorry, I just. My lord may see clause 8.8. Page, my lord, page 67 of the brief. The company, my lord, got that? Page 67.
Yes.
Towards the last. The company reserves the right to recover, enforce recovery of any overpayment detected after payment as a result of post-payment audit or technical examination or by any other means, notwithstanding the fact that the amount of disputed claims, if any, of the contractor exceeds the amount of such overpayment, and irrespective of the facts, whether such disputed claim of the contractor are subject matter of arbitration or not, the amount of such overpayment may be recovered from the subsequent bills under the contract, failing that from the contractor's claim under any other contract with the company or from the contractor's security deposit, or the contractor shall pay the amount of overpayment on demand. Now, my lord.
That means it may be recovered from a subsequent bill under the contract.
Yes, my lord.
But it cannot be an independent claim.
No. So, my lord, it has been recovered from the subsequent contract. Now, my lord, may I take your lordship to Annexer A/3 series, which is at page 97, my internal page is 12. There may be a difference between the pagination and running page. And page 12 of my counter.
Letter of 2/6/2013.
No, 22/5/2013. Just a page before that. Just a page before.
Yes.
My lord may see, consent to execute the work. MCL sought the consent of the petitioner to execute the work for the extended period. Your lordship may say, you have already executed such and such quantity against the awarded quantity of 20 lakh ton till 15/5/2013, as the work is of urgent nature to continue the work beyond the awarded period. Time extension is required under the existing NIT. Hence, you are requested to give your consent to continue the work beyond the awarded period in the same rate, terms and condition, or on the new awarded rate, whichever is lower. Now, my lord, how here the next, again another extension was given, which is on the next page. And for those, he replied, my lord, his consent is on the next page. My lord, may see the very next page.
That is 2/6/2013.
Yes, my lord.
Yes.
This is to inform you that we are aware about the schedule rate of date of completion of NIT 653 is dated 3/7/2013.
Yes, he says we are agreeable unless.
For applicability of price fall clause.
Next octave.
Yes, my lord. So now, my lord, having given his explicit consent, MCL having given a notice that if you want to execute, this is the applicability of the clause. If you are interested, you can proceed with the applicability of the clause, or it was open for him to get out. So, my lord, having given his consent explicitly, now challenging that, I showed your lordship, he filed an writ application in 2012, withdrew it. After there was an interim order, in spite of that, he withdrew it after a long time. Now, my lord, my closure of contract only says that price fall clause applicability is there, your liability is this. Shortfall penalty, majority of the amount was already recovered, only a fraction of the amount. Now, my lord, the total amount which is being recovered from him vis-a-vis a tender of 3 crore amount is 12,44,316, and 3 lakh of which is already recovered from the earlier amount.
So it is 9 lakh something.
9 lakh something is the amount. Now, my lord, what my submission is, my lord, in view of the fact that he was by way of hindrance register, he was aware of his penalties which are applicable to him. By way of consent, explicit consent, he was aware of the applicability of price fall clause. Now turning back and challenging that very document when it is made applicable to him may not be, my lord, available to him. Yes.
My lord, can I submit?
You are in the plan.
Yes, ma'am. I let me see that page 17 for a moment of the counter evidence.
Yes, we are at.
Yes.
6/2013 letter.
Yeah, that page 17 of that hindrance register, ma'am.
Okay.
Hindrance register.
Is 77 for something.
Yes, ma'am. Page 17 of the internal page 17 of the counter evidence. My lord may see when it is as per the original statement signed on the last bottom, my lord. Sorry. This is the last, my lord, as per the original statement, when it is signed, my lord, 25/3/2022. My lord, the work was completed in, my lord, 2013. Now they sign it on 25/3/2022. Now, my lord, I take it from the beginning, my lord, of the hindrance test. My lord may see the reasons of shortfall. Less dispatch due to RS1 jammed. Less the fault of only not the fault of the contractor. No, sorry, my lord.
This document is not contemporary.
My lord, what I am to submit. This is hindrance lister is a part of the general terms and conditions. Now they are trying to bring it to an evidentiary value, my lord, after 10 years.
Somebody has also put his signature on your behalf.
Right.
May I clarify? This is an extract. You may see the top.
That's what, my lord, I want to say. Hindrance lister.
Yes.
My lord, I am not saying the genuinity.
The signature of 22 is
my lord, I am not saying on the genuinity of it. I'm not on the genuinity of it. Because they want to sacrosanct their own impugned order, my lord. They want to press this hindrance register in 2022. My lord, the register has been maintained for that 1 year. And that in that 1 year, the fault is not only lies with the contractor, it also lies because of extraneous reasons, my lord. The road is jammed, strikes are there.
Sir, for that they have not charged you.
My lord.
They have exonerated you.
My lord, what they have charged me.
They charged you.
My lord, if not.
Only when will they find the less dispatch due to less number of tippers.
Less number of
no tippers available.
My lord, that is, my lord, because sometimes the road is blocked. All these things, my lord, that's what I am now coming to the. My lord, what I am submitting is now is this, that for last 10 years, you slept over the matter. You never give me a.
That is there. For that, their argument is that you immediately approached the court in 2012.
We
obtained the interim order, which put a fetter on them to continue and make a demand. That continued till 2019. You withdrew, and then
thereafter, my lord, from 2023, and they never gave me a show cause, my lord. They never gave me a show cause. Well, even if they are passing that impugned order, they are trying to bring a monetary claim on me. At least I am eligible for a show cause, my lord. That I should have explained them that no, this is not the correct approach. Yes. And in those, my lord, kindly see.
Yes.
In their counter, my lord, they are relying upon the letter, the extension letter.
26/2013.
Yes, my lord. Yes. 22/5/2013. Thereafter, my lord, I have given my response. Yes, I was agreeable for the extension period, and the terms and condition definitely has to be made applicable to me. But my lord, can they improve upon their impugned order? They have never
reply. You'll have to just counter that. You're not supposed to re-argue the matter.
No, I'm saying that, my lord, all these terms and conditions
already placed no matter.
My lord, my lord, I have given one judgment, MP power judgment, my lord. That judgment just Para 82, I am relying upon.
You have written in your note?
Yes, my lord. We are given that.
Para 82?
Para 82.
MP power.
MP power, para 82.
Paragraph 82.3.
Yes, ma'am.
Yes. Yes.
I rest my case.
Item 26.
On behalf of the history of the Honorable Court, I received instructions to file the counter, but in the meantime, the panel has come up. So,
learned senior along with me have appeared for the opposite party number one for the registry. We received. So, for the opposite party number one is concerned, we are appearing my learned senior.
Time to file in the reply.
Time was granted twice. I pray short date may be fixed, my lord, for you. But twice they have taken time. Twice they have taken time for filing it, my lord. Lordship may consider and fix a short date. That's what I am saying.
I was just thinking about it. Yes, economic has to go to book number one. Correct. Book number one. What is this? Zero.
Numberless.
We say it in numberless code.
We call it as.
There is no number here. In Honorable Supreme Court, it is 1, 2, but here it is Chief Justice Court. So that's the number.
We call it as numbers.
The market has wrongly registered with what?
Item 27.
Please, Your Lordship. The present petitioner has challenged the validity of balance sheet 3 years.
My lords, in item number 27, my lords, counter has been filed by OP number 3, my lords, registrar of the OP number 3, my lords, registrar of the High Court, my lords. State has not filed an independent counter as of now.
What is this matter? What is your judicial side?
It's the validity of section 8 of OPID Act.
No, Your Lordship, that is not.
Notification under.
Okay, registrar judicial, why is the party? Who is the minister?
Yes, sir. Your Lordship.
Is he connected with the judicial?
Yes, sir.
What?
It was taken in consummation of Registrar of High Court.
No, what is his? Who is he? Is he admitted in the service of the judiciary?
Yes,
Virus of this
How can you?
earlier when
saying that you are telling the virus of this
notification. But not section 8, Your Lordship. That is what
Notification is under section 8, my lords.
Then why the registrar of the High Court is made a party? I fail to understand why. It is maybe on the recommendations, but it is published by the state government. So why you have made a party?
Such can take steps to delete the same, Your Lordship. Because before we
have been taken already.
Your Lordship.
Actions have been taken.
Yes, Your Lordship. Actions have already been taken and it's the same.
And it's the establishment of designated court under OPID.
The registrar petition.
We have simply notification is that these are the courts who will be designated court for taking up all those matters.
Yes, sir.
This notification is shared.
Yes, sir.
The instant petition is filed, sending the notification dated 14.
So on the other occasions when this case had.
It does not mean, what is his role?
Your Lordship,
Registrar Judicial's role, just tell me.
Your Lordship, because it says that the
No, no.
conference of the High Court of Orissa.
This affidavit will also.
Yeah.
What is the notification? Is a governor, the honorable governor who has approved it. Now.
Your Lordship, may kindly peruse your Lordship's order dated 23rd July.
In this matter, Advocate General will assist your Lordship. Today he is not available. And may pray be taken up.
On 23rd July, they undertook that the learned Advocate General will apprise this Honorable Court since 3 months back.
Any other thing?
No step has been taken till date.
We are live, so I am not making any comment. Otherwise, I would have made it. How long will it continue, sir? It's an obligation. When? Sir, come and appear physically in this matter. This is the sensitive matter.
Yes, my lord. Since last more than 1 year, the post is lying vacant, not
But
filled.
you come and appear physically on the next day.
My lord, I have met with an accident. For that reason, I am unable to appear physically.
That is what I am saying. So when you will be able to move?
My lord, in the last week of November, my lord. Because there is some fracture injuries.
We are fixing this.
And middle, I am giving other repetitions are pending. I am giving the number to be tacked up.
Whatever, don't create too many. One is sufficient, other will follow.
My lord.
Last
Item
Figure number, give it a.
on 27th, man.
27.
My lord. 27. Obliged.
Item 29.
Which is the public interest litigation relating to mismanagement of the district mineral fund and violation of the district mineral mineral fund. On 2nd January, this court directed the statutory committee, state level committee, to conduct an inquiry and submit the report within 2 months. They, instead of submitting the report, they filed an application for time. Thereafter, on 21st August 2025, this court granted 2 months time to submit the report. We are collecting the documents from the respective departments.
Because there is an allegation, your Lordship, there is an allegation of irregularities. Because the fund, the district mineral fund has been routed to different projects through different departments. There are as many as 12 departments. Then pursuant to the direction of this honorable court, the state level committee as well as expert bodies of different departments, they have already submitted their report to the state level committee. And that was in fact placed before the, and those reports were placed before the state level committee, and the proceeding also I have enclosed mine. Now they are examining each and every report, and the final report has to be prepared by the state level committee, which is to be produced before this honorable court. Lordship,
now you have received all the reports.
All the reports of 12 departments.
Only thing is that
They will take, they are examining each and every report because they are
collate it and scrutinize it.
Yes.
And then give your opinion.
Yes,
and then-
that is
How long
voluminous.
will you take to give it?
But they have sought for 4 weeks time, man, in this. Because these are voluminous document and 12 departments, different projects, different, because the reports also, they are voluminous. Of each department is carrying around 400, 500 pages or maybe more than that. Man. That is why. Para 12 of that instruction, your Lordship, the allegations are extensive in scope and the inquiry reports submitted are voluminous and require careful scrutiny.
By order defeat 21, 8, 22, make difference.
Item 30. Item 3.
I left tomorrow. Because we cannot senior counsel to this case.
For
Tomorrow. It's for tomorrow.
he's tired or he's exhausted or what?
Somewhere
lakhs of the court. So next.
Next one. Item 31.
Next week.
Next week, Madam.
Yes.
So kindly give a date will be
19th.
19th.
Item 31.
Here in this case, single council was also engaged, but I am submitting.
Oh, the same senior counsel.
Yes, sir. Here is the case is that Lordship kindly see the last order. It is passed on 7/2/2020.
If you start, then you will finish. Then you have to finish.
Instruction was sir.
This, he's saying that he's not in a position to extract the that. Mr. Das. Report.
Leasehold area, he could not extract the sand because there was obstruction by the villagers. So.
It is not that.
Yes, madam.
There are encroachments and the miscreants are causing absence of the.
There were protests by the miscreants. We have filed that counter, but regarding that progress, what has happened, whether those miscreants have been, so that is not available.
There, action has to be taken, because the court says that you have to, that what action you have taken.
That I informed the producer also next week.
No, it is virtually over.
2027 August is there. I have already invested and compliant all of the condition. More than 1 crore I have arranging hand loan. I have invested in that sand corridor. But on my, there repeatedly say police protection is there. That I have also deposited the cost for removing the unauthorized 3 lakhs. Some of last order sheet it has been mentioned by it. And for removal of the
What you want?
Now that the zero tolerance policy has also come.
Absolutely, law and order situation
They will have
is a
to
big subject. If somebody is prevented from doing his livelihood, how can you not protect him? You have taken the money, you have granted everything, and will you not support? Next week you submit the report. By order sheet 7/2/2025, the steel was directed.
You will also be